My name is Myesha Braden, and I'm Director for Special Justice Initiatives here at Alliance for Justice. Welcome to the inaugural presentation of our new virtual conversation series, May I Approach? Courts and the Power of Inclusion. For those of you who are new to AFJ, since 1979, AFJ has been the leader in advocating for fair judiciary filled with highly qualified individuals who possess the temperament, integrity, and skill to be exceptional jurists. It leads the charge for nominees whose professional reputations and personal histories demonstrate that they will be fair-minded and unbiased jurists who are committed to the principle of equal justice under the law. Last year, AFJ established its Building the Bench initiative with the goals of establishing a robust pool of federal judicial candidates ready to be nominated at the beginning of the next administration, identifying and recruiting judicial candidates from historically underrepresented groups, and advocating for judicial nominees who represent a wider range of demographic and experiential diversity. We are so excited to have you with us tonight to discuss a topic that is very recently in the news, and we are excited to have such a wonderful panel of guests with us this evening. We will introduce you first to our moderator, someone whose face you may recognize. Professor Melissa Murray is the Frederick I. and Grace Stokes Professor of Law at New York University School of Law, where she is also faculty director of the Birnbaum Women's Leadership Network. She's a leading expert in family law, constitutional law, and reproductive rights and justice. Prior to joining NYU's faculty, Professor Murray was on the faculty at the University of California, Berkeley School of Law. And from March 2016 to June 2017, she served as its interim dean. She's an honors graduate of the University of Virginia and Yale Law School, and a former law clerk for now Supreme Court Justice Sonia Sotomayor. Professor Murray has written for popular publications like the New York Times, the Washington Post, and Newsweek, and you've probably seen her face on television offering insightful commentary for media outlets like CNN, MSNBC, and PBS. Joining Professor Murray is the Honorable Bernice Donald, a United States Circuit Judge for the U.S. Court of Appeals for the Sixth Circuit, which covers Kentucky, Michigan, Ohio, and Tennessee. Judge Donald received her law degree from the University of Memphis Cecil C. Humphrey School of Law, a master's in judicial studies from Duke University, and an honorary doctor's in law from Suffolk University. When nominated to the U.S. Court of Appeals by President Barack Obama in 2011, he praised Judge Donald for having shown an outstanding commitment to public service throughout her career and during her 15 years as a U.S. District Judge for the Western District of Tennessee. She's been a staff attorney at the Memphis Area Legal Services, a litigator for the Shelby County Public Defender's Office, and in 1982, when she was elected to serve as a judge on the Court of General Sessions in Shelby County, Tennessee, she became the first Black woman elected judge in the history of Tennessee. In 1988, she became the first Black woman in the nation to serve as a federal bankruptcy judge. Judge Donald is actively involved with the American Bar Association, having served as chair of the ABA Center for Human Rights, chair of the ABA Criminal Justice Section, and most recently as a member of the ABA House of Delegates. Joining Professor Murray and Judge Donald is Dean Danielle Holley-Walker. Dean Holley-Walker is the Dean and Professor of Law at Howard University School of Law, the oldest HBCU law school in the country, established by John Mercer Langston in 1869 at the height of post-Civil War Reconstruction. Dean Holley-Walker earned a BA from Yale University and her JD from Harvard Law School, after which she clerked for Chief Judge Carl Stewart of the United States Court of Appeals for the Fifth Circuit. Her legal scholarship focuses on issues of educational equity, and as dean, she has pushed Howard Law School and its peer institutions to produce more lawyers in civil justice reform, voting rights law, immigration, and education. And rounding out our tremendous panel this evening is Justice Adrienne Nelson. Justice Nelson was appointed to the Oregon Supreme Court on January 2nd, 2018, making her the first African-American to sit on the state's highest court in its 158-year history. Her election to a 6-year term in November 2018 made her the first Black woman elected statewide in Oregon. She previously served as a trial judge on the Multnomah County Circuit Court, as a public defender with Multnomah Defenders, as an associate with the Bennett Hartman Morris and Kaplan law firm, and as a senior attorney with the Portland State University Student Legal and Mediation Services. Justice Nelson earned her BA in English and Criminal Justice, summa cum laude, from the University of Arkansas, and her JD from the University of Texas at Austin. She is also an active member of the American Bar Association, where she served as a member of the House of Delegates and the ABA Commission on Disability Rights. And with that, I will leave you in the hands of our capable moderator, Professor Murray.
Thank you so much for that, Myesha, and thank you for all of your hard work in bringing this program together. And I also wanted to say a very hearty thank you to Nan Aaron, who has been the indefatigable leader of the Alliance for Justice for as long as I have been in the law. I still remember being a first-year law student and doing a research project that required me to write to Nan to ask her about all of the demographic information for the federal courts, which she seemed to have at her fingertips. This was before smartphones, but she still did it with incredible ease. So thank you for all of the work that you do, Nan, and all of the work that Alliance for Justice does. It's a great pleasure to be here with these fantastic women, all of whom are sheroes of mine, and to have such a terrific crowd. And so let me just kick it off. We have all been talking about the Supreme Court this week. There have been some really momentous decisions being handed down by the court, and we've seen the Supreme Court become even more of a player as we begin the long march to November and the 2020 election. Joe Biden, who is the presumptive nominee for the Democratic Party, has announced that he will select an African-American woman to be a Supreme Court justice if a nomination presents itself during his tenure as president, if he's elected. But when a list was composed, or at least attempted to be composed, it turned out that there actually aren't a lot of African-American women sitting in the traditional places where justices of the Supreme Court traditionally have been drawn. So typically justices are fed from the United States Courts of Appeals, or barring that, the state courts of last resort. And interestingly, African-American women are not terribly well represented in either of those venues. So I will pose this to you ladies. Both Judge Donald and Justice Nelson are in those positions, but they're often alone. So what are the impediments to African-American women being in those positions, appellate judgeships, whether at the state or federal level?
Well, I want to thank the Alliance for Justice for presenting this program, and thank you for inviting me to participate. You know, Professor Murray, I think that the issue you address is really critical. When we talk about where African-American women are located, and they're not a number in the traditional places that they come from, but I think that's a problem of where appointing authorities are looking. Because I noticed that in the past, appointing authorities, especially at the federal level, have looked at, as you mentioned, lower federal courts and state courts. They've looked at large law firms, and they've looked at prosecutors' offices. We don't have a lot of African-American women who are in the federal prosecutor's office, or we have many of them in large law firms, but that people can make a personal decision whether or not they want to leave a lucrative practice to take a position where they're on fixed income, even though it may be fixed higher than some, and it has the benefit of lifetime appointment. People have to make different decisions. But I think that diversity on the bench is so important, and I don't just mean the racial and ethnic diversity, but I think experiential diversity. Having women who come from different backgrounds is critically important. And so appointing authorities need to look at women who are in government service, women who are in public defenders' offices, women who have been solo practitioners who certainly know how to manage and navigate people who serve in high volume courts. I remember as a part of my ABA experience, I chaired at one time a group called Opportunities for Minorities in the Judiciary. And we convened a meeting in DC where we invited the Clinton White House person to come and talk with us, because we had that same issue then. It was at the trial court and at the appellate court. People were looking in traditional places. Now, President Carter looked at a lot of civil rights lawyers, but then subsequent presidents didn't look there. And so we said to the council, understand that the court needs every experience there. When we look solely to people who come from select perspectives, we get a skewed perspective, but the court is dealing with all manner of issues, and all of us bring the sum total of our lived experiences to the bench. And it is the amalgamation of those lived experiences that I think help us produce a better quality of justice. And so appointing authorities ought to be tasked with looking broadly and differently, not just doing check boxes, but bringing America to the bench so that people understand perspectives that women and poor people and people in government service face. I think that's the task. We have got to not accept the status quo when it comes to where we pick judges. They have got to broaden that. And certainly, as we're in this year where we're looking at and commemorating the 19th Amendment, it seems like African-American women always get the short shrift. We do the work, and we are a reliable voting group, interest group, if you will. But then when it comes to this representation in the various echelons of the judiciary, we're not there. And it's critically important that we be on the appellate bench, because that really is oftentimes the end point when it comes to the federal system. The Supreme Court takes very few cases, monumental though they be, but they take very few. And so most appeals that are in the federal system are going to end at the circuit courts of appeal. And so it's really critical that we have real diversity in terms of all of those dimensions of diversity that we think about, to bring a higher quality bench that understands the lived experiences of people.
Did you want to follow up, Justice Nelson?
Well, first of all, I'd like to also thank the Alliance for Justice for putting on this program, and Myesha and Nan and Keith for the work that they've put in. It's hard to add anything to what Judge Donald said. I mean, she really was quite comprehensive in her remarks. The only thing I would say, as someone who's currently sitting on a state Supreme Court, which is a court of last resort, I concur with everything she says. And I think that it is really important that, depending on how your judges in the state courts are appointed, some are appointed, some are elections, some are through commissions, that you familiarize yourself with that process, and that you encourage people early on. It's really important to develop that pipeline, and as well as to encourage the authorities who are making the decisions to understand what the expansion means. There's a lot of studies that have been done that explain the value of it, but I think people like to hear locally from their people to know what it is. And then as they see across the country in other jurisdictions, not necessarily their own, the success that they're having and how the courts continue to work well, but maybe even better and smarter because there's no diversity, they'll come to the idea that they need to embrace it.
So Judge Nelson, to toggle back to something you said, does the fact of judicial elections limit or expand opportunities for Black women? I mean, with the appointed judges in the federal system, it's a pipeline issue, but in the situation with the state judges, those are elected positions often.
Yes.
Is that a problem for Black women?
I think it can be. I think it can definitely be a barrier. I mean, I can say the fact that in the bio that was read for me that I, in 2018, was the first Black woman to be elected statewide in Oregon seems like it's a big successful thing, but it's also, while it is, it's also a very daunting task. And I had a lot of people say to me, how are you going to do that? you know, especially understanding the demographics of the state. And so I had to be very clear about why I was running and being able to fundraise, because that's a factor. I would say to people that that should not be a reason not to apply, because there's always people that can help you. And it's something that you can learn. If you went to law school and graduated and practicing, you can run for an election. It may not be the most preferred thing that you want to do, but you can definitely do it and do it well.
And Professor Murray, if I could just say this, I agree with Justice Nelson that it has its advantages and disadvantages, but I firmly believe that had I not run for election and gotten elected judge first, I would never have made it to the federal bench. The mere fact of that election brought me to the attention of people later on who had the ability to help move my career into a different trajectory. So in Memphis, we have now a number of African-American judges and a number of African-American women judges on local benches and on state benches. Those judges are almost unanimously elected to that office. Now, only recently, when the demographics of the city changed and appointing authorities had to be responsive, did they begin to appoint those individuals. Doesn't mean that there weren't qualified people all along. And I know that once again, when people use that term qualified, it means different things in different places, but these people are doing a fantastic job, but they would never have had that opportunity but for the people saying, yes, we're going to put you there.
So what
Oh, I'm sorry. Actually, I have a question for you, Dean Holley-Walker. You are the Dean of Howard Law School, which produced the first African-American jurist to the United States Supreme Court. And now you oversee a cadre of almost 300 students a year graduating. Some people argue that this is a pipeline problem, that there aren't enough African-American lawyers being produced. Is that a fair assessment?
I don't think it is. I think, you know, we obviously are still, as African Americans, well underrepresented in the profession. We're only about 5% of the profession when we're about 12.8% of the population. So we are very underrepresented in the profession, but we are even more underrepresented in many areas of the judiciary. So we're even less than 5% in most areas of the judiciary. So we're even more underrepresented than we are in the profession. I think one of the main pipeline problems is definitely this question, especially on the federal bench, of experiential diversity, as Judge Donald talked about, but also the tendency of the people who appoint to appoint judges who very much look the same on paper. So it's interesting that Justice Thurgood Marshall was a Howard graduate. And there are other Howard graduates who sit on the bench, but most of the judges on the federal bench right now went to about 3 or 4 different law schools, make up most of that. And so I think another area of diversity that we really need to look at in terms of encouraging whoever is the next president to expand diversity on the federal bench is to really ask them, what are you looking at in terms of the educational background of the people who you appoint? I think that that's one of the key questions, because if you look at just Harvard or just Yale or just Stanford or Columbia, you end up with a certain pool for those positions. And it is a pool that is not extremely diverse. I'll say in terms of elections, the point that I jumped in to make was, I'm from Texas. I was raised in Houston. In the 174 years of the Texas Supreme Court, there has never been a Black woman on that court. And so when we talk about judicial elections, it's one of the things that we have to I tremendously agree with Judge Nelson and Judge Donald about stepping up to run for office. So like Judge Stacey Williams is a candidate now for the Texas Supreme Court. And I think it's really important that Black women step into that arena. It requires a lot, including raising money, which we need to, talk to, I think, people in the pipeline about what it really takes to be elected to many of these positions.
With that in mind, can we talk a little bit about the position? So I think a lot of us have some general understanding of the difference between trial courts and appellate courts, but can you talk specifically about the work that both of you do as a justice on the state court of last resort and as a judge on an intermediate federal appellate court?
Judge Nelson?
Well, I can tell you that our court takes a little bit larger percentage of cases that come before us in our discretionary role, because we also have some areas of mandatory review we have to do. So we take about 7% of all of our petitions over a year. And what we will do is we meet in a group. So there's no more as a trial judge sitting in your courtroom and deciding the issues or presiding over a case. You're in a group of 7. And in my case for the state of Oregon. Then you have to consider what the issues are. And then you write along with your staff attorney or your clerk to come to a conclusion, but that doesn't necessarily end there. Once you're assigned to a case to write the draft, you also have to be persuasive. You not only have to persuade your other colleagues that the way you've written or seen an issue is correct, they have to be persuaded enough to want to join it. And that's how you can get a unanimous verdict, and a unanimous opinion. And if not, there may be a concurrence on a particular issue, or there may be a dissent. So you have to be in a position to have the legal ability, the acumen, if you will. You also have to have an ability to do the research and writing. You also have to have the ability to be persuadable while you're also trying to talk about the moral truth of things, because I think that comes up a lot for people in those private settings. It depends on the courts, but I can tell you in our court, it's just the justices in the courtroom. In our conference, it's no one else. So some people may like the collaborative perspective, others may not. But I can tell you, having done both, I see the benefits of both. And I was looking forward to thinking deeply and writing about issues, which is why I applied for the appointment on the state Supreme Court when it came open. And it was also at a time where there were no other trial judges on the bench. The other justices who had a trial background had retired, and I felt very strongly that each state Supreme Court needed to have that diversity of experience while they had justices considering issues that will often never be considered by any other court in the country, including federal courts.
Judge Donald?
Okay, and the process on our court is much like Justice Nelson described, except I sit as a member of a 3-judge panel. Most of our cases are 3-judge panel cases. We do get en banc where the entire court sits, and we don't have the discretion to decide which appeals we're going to take. I mean, whatever comes up, we review for, first of all, jurisdiction, and then for whatever the issues are. We do have the discretion of hearing oral argument in a matter or deciding it on the papers. And as you might imagine, the bulk of our cases are decided on the paper. We, as federal appellate court judges, get 4 law clerks if we like, or you can have 2 administrative people and 3 clerks if that's what your preference is. And so we get a lot of work. In terms of the court, most of the cases that we decide are generally unanimous on the 3-judge panel because many of the issues are non-controversial. But there are cases that come before the court that are very controversial, and we almost always have an en banc, at least 1 per quarter. Those cases sometimes reveal ideological splits, and they become very difficult. And we all, I believe, make the assumption that all of us come to the work with a desire to decide the case on the law and come to those positions in good faith and come from a principled position. I have, in my time on the bench, because our court has changed since I went on, so I've ended up in the position of writing a number of dissents on certain cases. And I try to always do that from, as Justice Nelson said, a moral perspective and have it strongly rooted in law. There have been times when I have started out in conference advocating something and have been able to bring my colleagues with me. We don't confer on cases before the hearing. We only confer after. And as Justice Nelson said, there's no one other than the sitting panel or the en banc court in the conference room when we discuss those issues. Now, lately we've been hearing matters on Zoom, so maybe there's been a broader audience. That has been an experience, and I think it's been a good experience. I hope that our court will retain some of those practices because it does represent an access to justice issue. There are other people who would never have an opportunity to come and sit for oral argument because we only meet we meet primarily in Cincinnati, and occasionally we will meet at a law school under a special circumstance. But I want to say this, I came to the court somewhat reluctantly. I didn't seek it. It sought me. And when I say that, it goes back to the point you mentioned earlier, Professor Murray. I happened to have been on a trial court. A vacancy was coming up that I didn't even know about, even though it was right in my building. And a lawyer from Nashville called me and said, next year, there's going to be a vacancy on this court, and some of us in Nashville have been talking about it, and we think you should apply. That was my first knowledge that this vacancy was going to occur, even though the vacancy was 2 floors up from me in my building. And I hesitated for a time, but eventually I was persuaded to seek it. I think I want to dispel what I believe is a misperception. Sometimes I think we wait to be selected.
Right.
And then sometimes we deselect. We look at a position and we say, I can't check every box for that position, so I'm not going to put myself forward. And I think as African-American women, we have been trained not to be self-promoters. But there are times when you have to step forward and offer yourself up for service. And you have to let people know that you are interested. And Justice Nelson mentioned before that once you step out there, whether it's for election or appointment, you will get supporters and allies. But you've got to make that first step. And you've got to make sure that you're in a position when that opportunity comes to step in, which means that you've got to do the work before that point. And you've got to understand what all of this entails. And you've got to make certain that people who are in a position to influence that appointing authority know that you're interested and that they are willing to be an ally for you. Because this person that I'm telling you about who called me, the person who called me was a white male from Nashville that I didn't know all that well, but he knew of my reputation. Mm-hmm. And I will tell you that he worked harder than anybody ever ought to be expected to make this come to fruition. And I also want to thank organizations, because in my quest for the district court and the appellate court, I think the Alliance for Justice and other organizations were right there carrying the water and doing lots of things that I never even knew about to make sure this happened. So, when I tell that story, it sounds like it was smooth on the front end, but there were a lot of people who formed alliances and who did the groundwork to make sure that that I was able to get there and that we have this diversity. And so once we get there, it's important for us to make certain that we recognize other people are watching us, and our service, our performance may enlarge or diminish the opportunities for other people. And so it's a sacred trust that we have been given.
Right.
So let me just interject. We are about 30 minutes into it with another 30 minutes left. If you have questions, you can submit them by the private chat to Rachel Bracken. So Rachel Bracken can accept those questions privately, or you can submit them to buildingthebench@afj.org. That's buildingthebench, all one word, @afj.org. So please submit your questions to us through that vehicle. But I still have more questions, so don't worry. So let me offer up 2 questions, and you can decide which you would like to think about. Justice Sonia Sotomayor once noted that she was a wise Latina and that she brought her experience as a wise Latina with her to the bench. And when she said that, she was actually riffing on something that Justice Sandra Day O'Connor had actually said years earlier, referring to her own experience as a woman. Justice Sotomayor obviously got a lot of flack for that, but arguably, she's right. Her position, her experience has informed her work as a justice. So I'd like to know, In your role as judge or justice, do you see your experience informing the way you make decisions, or even in how you are viewed by your colleagues or the public at large? And separately, given the nature of the legal profession and how important these positions are, is it important to have a diverse judiciary, if only for the purpose of having a diverse cohort of clerks? Like, many of the clerks of color currently working in the federal courts and in the state courts are working for judges of color as well. So what does diversity, or the lack of diversity on the bench, mean for the pipeline of young lawyers coming through our profession? So 2 separate questions for you all. And Dean Holley-Walker, why don't I take you first?
Thank you so much. I think number one, I mean, with Justice Sotomayor, I think that, the false notion of neutrality, right? That neutrality comes from a white male voice, that is the neutral voice. And that anytime you're a woman or you are a person of color, that you are therefore coming from a not neutral place. And so I think the truth is we are all informed by our lived experiences. Where did we grow up? Obviously race and gender, ethnicity, all of those things hugely affect our perspective and the way that we view the world. And that's true for everyone. But I think, as you said, when Justice Sotomayor said it, it was thought to be something that was almost inappropriate for a judge. Instead, you're supposed to call the balls and strikes, as Justice Roberts would say. You should be someone who's there as an umpire calling the balls and strikes. And I think what Justice Sotomayor recognized, which is absolutely true for all of us, that we are all informed by our lived experiences. And I think her saying that was really important, because I think for many people, one of the reasons why we take ourselves out of the running, as Judge Donald said, is we believe that we may have to strip away parts of ourselves to really get into that game. And no one wants to be someone who they're not, right? So I think it's important that Justice Sotomayor has led the way in many ways in saying it's okay to acknowledge that you are informed by that. I would say as for clerkships, this is a very real and I think urgent issue. We look at the lack of diversity among the law clerks on both the federal level and on the state level. The truth is, when I advise a student about whether they should apply for a clerkship, I tell them to go right for the Just the Beginning Foundation group, which is the group of Article 3 judges, African-American Article 3 judges, because I know almost all of the diverse clerks are hired by diverse judges. So when I clerked on the Fifth Circuit Court of Appeals, there were 3 African-American clerks on the entire Fifth Circuit, and we all worked for Judge Carl Stewart. And so many of my students, when they go to clerk, if they clerk for a Black judge, they are the only Black law clerks on the entire court. And I think we have to address that issue, because that's a pipeline issue, right? Mm-hmm. Because if you don't get the clerkship, then the question is, then someone may say you're not qualified for the next big job, whether it's a law firm partner or a federal prosecutor, and then all of a sudden you don't have the qualification that you need to be appointed to the federal bench. So we have to address that pipeline issue. And one of the ways to address that pipeline issue is to appoint more Black women to the bench, to appoint more people of color to the bench.
Judge Donald?
Well, I certainly agree with Dean Holley-Walker. I want to say 3 things. First, I agree that a lack of diversity in law clerks is a huge issue. There are very few African-American law clerks who clerk for the Sixth Circuit. Judge Damon Keith used to always have diverse law clerks, and when you look at his alumni roster, they're stellar. I have always said that I want to be surrounded by diversity. I don't want everybody who works for me to look like me or think like me, because if that happens, there's nobody to help me guard against my blind spots. But when I looked at our court and we had almost no diversity on one occasion, I decided with great intentionality that I was going to hire non-diverse clerks. I hired 4 African-American women. And we would go to court, 5 African-American women, the judge and her 4 clerks, because I wanted to start a conversation with my colleagues. Now, there probably was a conversation, but it was not with me. You know, the quality of the work didn't suffer. So we know that people are talented. And when people say, I can't find qualified clerks of color, it just baffles me. But I think that comes in how you define and qualify, because we're at every law school. People are out there, and not everybody, as you said, Professor Murray, not everybody can hire from Harvard or should hire from Harvard. Yeah, there are great law schools around the board. And I've talked to the Supreme Court justices about the lack of diversity, because, you know, if you need someone to help you guard against those blind spots. So I agree with that. I also think that as judges, we have to proceed with intentionality on helping our colleagues understand the importance of that diversity. Jeremy Fogel and Goodwin Liu, along with some others of us, have teamed together to start looking at federal law clerks and why we have so few, and what judges are looking for. And there's been a survey developed that we're going to be sending out and people are going to be taking. But it's an issue that is overdue for being addressed, because whether or not you get a federal clerkship or even a state appellate clerkship can really, as you said, enlarge or diminish your opportunities going forward. And you know, I was never a clerk, so I didn't have that experience, and nobody ever talked to me about the value of that. But it is an incredible opportunity, and we want more people to have it of diverse backgrounds.
Justice Nelson, do you want to add something?
Sure. I would say that since Justice Sotomayor made that comment, there have been a lot of discussions, and hopefully, in my opinion, some awareness of the comment being placed in the context that she probably initially intended. But what I do is make it clear, both when I was a trial court judge and currently, specifically when I first walked in, I let them know that I brought my whole self to work. And when I said that, it meant that I clearly a Black woman, but I'm also someone from the Deep South who's living in Oregon, who has a perspective. So I understood rural communities in a way that maybe others did not. And that all of that was valuable. And it sparked both public and personal conversations. And I can tell you that the people who were making decisions, from the committees and advisors of the governor to the governor herself at this point, really had, along with my experience and others, valued that. So I think that people should definitely talk about it instead of trying to fit in traditional molds. I think that there's a need to be who you are and explain why it's a value and not necessarily a negative. That's really important. The intentionality is key. I too made a decision to hire clerks of diverse backgrounds. And it was interesting because people often ask me, where did you find them? And I was like, I went to the law school. You know, I asked, it was like, so I was willing to have the conversation about where you find them. And they were like, oh, well, can you send me? And what was interesting that happened is people were like, so the people that you did choose, can you send them to me? Because I want to interview them. And then we started to have a pool, particularly at my trial court, of diverse clerks that, you know, so it was a really interesting connection that was being made that was intentional on my part and hopefully intentional on theirs. But it's really important to me about the pipeline issue. Our court, as a state court, Supreme Court, we go to the 3 Oregon law schools every year, and we go to their first year classes. Well, the first year class has to come when we come to the campus in March. So I look around the room to see who's sitting in that classroom. And then I make sure that I have access to them. We have a separate session with first generation and students of color and people who are from other marginalized groups to have conversations to ask about what it means to be in this position, how law school is, how to demystify, how for them to find their community and not feel like they're the other. And I think that we have to be honest about our path. I mean, often people will say you don't understand what you haven't experienced and you don't know what you don't see. So having been in the role that I sit in, I feel like I do have a responsibility, not for people who just look like me, for people who don't, so that they can understand what the value is for the different qualifications, if you say that, or for the different qualities of what I think makes a good judge justice.
Professor Murray, could I say one other quick thing? Because Justice Nelson just reminded me of talking about the pipeline issue. One of the things that we're doing in Memphis right now is exposing students earlier to the law. Last Friday, I sat as a judge in a moot court performed by high school students. We have a summer youth program to encourage students, you know, instead of going to a traditional employment setting, we have created a pool of opportunities in law firms, government, and business where high school students can get exposure to the law. So they get trained, they get a small stipend, they get to actually sit with the lawyers, and some of them do real work like operating the technology that lawyers aren't so good at, but they get to be in that environment, and it causes them to think. And when Justice Nelson talked about knowing and seeing, I think as people learn and enlarge their universe of opportunities, then more of them may aspire to law. We've had some people come out of that program and actually graduate college and go to law school. So we're talking about building the pipeline much earlier.
And if I can just add, you know, I'm in an American in a court, and we made a decision over a decade ago to fund a mock trial class at the request of one of the teachers at a school that has a majority student of color population. And then we have been their coaches, and we come in throughout the year. And even if they don't decide to go to law school, they have learned about the legal system. They are very informed of what their rights are. They're able to talk to other students. They become fully engaged citizens. And it's just been a really strong benefit of our end. We feel like we're not doing our part, but we're creating a new generation of informed citizens who potentially can be lawyers and judges, you know, which is our personal goal, but not necessarily theirs.
Well, so let me pose a question from the audience. So one audience member would like to know how attorneys can support judicial diversity. And you've touched on a little bit of this, maybe doing pipeline programs with high schools or with law schools, but this seems to be an even bigger question given how politicized the country has become, and especially in places like Oregon, which may not be as diverse. So how do we cultivate a more diverse judiciary as lawyers in some of these places where the pool of lawyers may not actually be diverse at all, but can be quite homogenous?
So I think it would be interesting for people to look around and see who's in the courtrooms, because that's a perfect place to start to think about somebody going on the bench. If someone's in a courtroom litigating, they could be a potential judicial candidate, you know, and watching and asking them what they think about it. Maybe taking them out and explaining the process, because I can tell you a lot of people just don't know what it means to sit as a judge, either at a trial court or an appellate court. So they may not even consider it as an option. I know that I didn't. The first African-American female judge in our state of Oregon told me over lunch, she hoped she lived long enough to see me go on the bench. I couldn't imagine why she was saying that to me at the time. I didn't question it, but she planted that seed. And I think that not just having someone who looks or having a diverse judiciary helps people think that maybe I fit in. It's also tapping someone and saying, hey, had you thought about that? It could be as simple as once they did a really good argument or won a case, sending them a note and saying, hey, can I talk to you about something else? You know, and just bringing it up. And if you're in a space where you can make suggestions, put that person on a list and talk about why it's important. That's what lawyers can do, just like Judge Donald talked about how she was tapped to go from the state court to the federal bench. Those things actually happen and they matter. And there are some people who are not going to self-select at first. But once you plant that idea, they'll take it on and build that reputation.
I
And that resume.
will also say, as a law professor, that's also works in terms of clerks. I mean, I think a lot of clerks of color are encouraged because someone taps them on the shoulder and says, I think you'd be great for this. So if you're an attorney and you have summer associates with whom you're working this summer, if one of them is especially good as a person of color, please tap them on the shoulder and tell them to consider it, because they're probably not hearing it from a lot of quarters as well. So with that in mind, what do we think of this question of viewpoint neutrality? Danielle Holley-Walker, you mentioned this earlier, but there are a lot of tensions right now in the country around the question of viewpoint diversity versus diversity of experience, the questions of ideological diversity. Is it helpful for us to frame our demands for a more diverse judiciary in terms of diversity, or should we be more specific about what we want, given how the term diversity can be deployed in ways that perhaps are not the ways we intend?
I think one of the things that I typically talk about with audiences who are thinking about this question in particular is just this notion of having confidence in our courts and in the rule of law, right? I think many times when we see communities that have, significant minority populations, and even in some that don't have significant populations, like out in Oregon, when you look at your judges and you see that your judges are not representative of the people in the community, that causes a crisis of confidence in the courts. And I think that that is something that we are seeing that is really eroding our confidence in the Department of Justice, our confidence in the way that our federal courts operate, our confidence in the Supreme Court. Much of that is being questioned because average everyday people do not feel that our system of justice really represents them. And so I think outside of talking about diversity, I think we need to talk about what does it really mean to have a rule of law system in the United States that is representative of the people of the United States. So when we see, in a way, how outsized the representation is for certain parts of the demographics in the United States, I think it really calls that into question. And we need to talk about this as really a question of representative democracy.
To add some context to that, in the federal judiciary, currently 80% of sitting federal judges are white, and 73% of all sitting federal judges are men. So, I mean, it is grossly skewed, and it has become increasingly skewed over the last 4 years. So we have about 9 minutes left. And if we have any more questions from the audience, I've gone through our audience questions, but if there are more, please feel free to send them to Rachel or to send them to buildingthebench@afj.org. But let me just sort of finish off. If you had one thing to say to someone thinking about this career, what would it be? So if you could have the last word with someone, what would you tell them about this profession, about the need for a more diverse judiciary, and how to encourage others to come along with you on this journey? So Judge Donald, I'll go to you.
Well, I would ask I would suggest to people that you think deeply about what brought you to the law, what anchors you, and what inspires you. And I'm sure those same things are needed to anchor and inspire and build confidence. More than 50 years ago, there was a survey done by the then National Conference of Christians and Jews, and it found that overwhelmingly, African Americans believed that they could not get a fair shake in courts, civil or criminal. That was followed closely by Latinos and then by Asian Americans. Now, Native Americans were not sampled or surveyed, but whites had the highest level of confidence. And we have to ask ourselves, why is that? But the fact that people believe that they can't get a fair shake in court, that's an indictment on all of us who are stakeholders in the system, and that's all of us. And so I would say, examine who you are, what you're doing, and how you build confidence, and how does an absence of diversity make you feel?
Right.
Justice Nelson?
You know, I don't have much to add than that. I mean, I think that that is so important. What I'll do is add an anecdote. So in 2006, when I got appointed to the bench in Oregon on the trial court, people actually came to see me sit on the bench because they would say, I never thought that would happen in my lifetime. I even had defendants say, you will never see me again in this posture because it's something that just happened that I never thought I would see, you sitting up there. But it wasn't just people of color. There were people from all types of demographics. And I could tell you that what would happen in my trial courtroom was a little different than what happened in my other colleagues' courtroom, because people who came from different demographics, particularly lower socioeconomic status, felt that they could be more open in my courtroom for whatever reason. And that made a difference. So there was this intersectionality occurring that people hadn't assumed would happen. And then it opened up conversations with my other colleagues. So when I got appointed to the Supreme Court in 2018, they had an increase in interest in what they did. And some people jokingly said because I was popular, and I said it's not because I'm popular, it's because I'm visible. And I tell people that courts belong to everyone, which they do, and they need to be engaged so that they understand what's going on, and we need to make it accessible. And I think that that goes into the trust and confidence, because it doesn't have to turn out the way they want, but it needs to be an environment where they can understand what's going to happen, how things are going through the process, and actually the result that is expressed in a manner that gives people an opportunity to absorb and accept whatever the result is.
Jean Holley-Walker, did you want to add something?
Sure. I think just two things. I would say for everyone on the call who may be a woman, a person of color, don't take yourself out of the running. I think so often when someone says, oh, you would be great as a judge, often the response that you hear back, oh no, I could never, do that. And I think a lot of times all it takes is saying, yeah, that is something that I would think about. And then beginning to talk to more people and beginning to network in that way and stepping up for yourself first, because if you don't step up for yourself first, a lot of times other people won't step up for you. And the second thing is we really do need to re-examine our pipeline programs, going all the way back to middle school, then high school, then college, and really thinking about the way that we encourage law students to clerk, but also even if they don't clerk, when they are very early in their careers, first, second, third year in their careers, encourage them to get involved with the ABA. Encourage them to get involved with AFJ, encourage them to really think about what are, American ends of court, encourage them to really take all those pathways that could expose them to enough people in the profession that they will be thought of when it is time for these appointments.
So we only have a few minutes left, and I want to just shift us from thinking individually, what can we do to encourage individuals to think about this path, to sort of thinking about what the implications of those individual choices would be for our institutions and our systems in the United States. And so an audience member has provided the perfect segue for that. This audience member notes that in response to the recent protest around police brutality, a number of state Supreme Courts have released statements acknowledging the roles that judges have played in creating a fair and equal system in which individuals of police violence can receive accountability from their violators. What other implications can we see given this particular moment where there is so much discussion going on about racial violence in this country, about inequality in this country? In what way can a more diverse judiciary be impactful on these broader questions? Justice Nelson?
Well, I'm proud to say that I'm one of those state Supreme Courts that issued one of those statements. And I can say to you, if you look across the country to see those state Supreme Courts who did such a statement, most of them are diverse. And so I think having a diverse judiciary, just for that point, it proves why it's important to have that variety of ideas. it also helps people to bring their various lived experiences so that they can uphold and support the rule of law. It helps them understand that our system, while it may be the best system that's out in the world, still has its imperfections and things that we need to have addressed, and that we have to come together to not only look at that and acknowledge it, but actually take action. For example, in our state, not only did we send out that statement, but we have been working on a statewide strategic plan. And so we're working on doing a variety of things, not just diversity, and equity, and inclusion training, but other things to really talk about the system, and probably going to have some statewide listening sessions. I had done some at the trial court level, and we're hoping to do that statewide. But I think that that's really important to help build the trust and confidence of the public to actually live up to our statement of equal justice under the law, to actually live up to that, as well as to make sure that everybody is having a fair and having fair and equal access to our courts.
And I know that we're almost out of time. I'm not going to speak directly to that, but I would say that another court that issued that statement is the North Carolina Supreme Court, that has one of the 2 African-American female chief justices.
That's right.
And I don't know that people realize this, but there have only been 4 African-American women to serve as Chief Justice of a state Supreme Court in the history of the United States. Leah Sears out of Georgia, Peggy Quince out of Florida, Burnett Johnson out of Louisiana, and Sherry Beasley out of North Carolina. That is amazing to think, as long as this country has stood. And that speaks again to where you started, Professor Murray. People have not seen enough African-American women in these positions, and we've got to have more.
On that note, we're at time, or exactly at time. So I just want to say thank you to our terrific panelists, Justice Nelson, Judge Donald, and Dean Holley-Walker. This has been an amazing conversation. Thank you to Nan and Keith and Myesha and the folks at Alliance for Justice. And thank you to our terrific audience for those outstanding questions. Myesha, I'm going to turn it over to you.
Thank you, Professor Murray, for doing an amazing job as our moderator. And I want to invite everyone to return next month. May I Approach is an ongoing series, and we look forward to the opportunity to discuss all the different ways that diversity and inclusion benefits the rule of law. The courts are our 3rd branch of government, and it benefits all of us to pay attention to what's happening in the courts. Professor Sally Kinney at Tulane's Newcomb Institute says that it profoundly matters who judges are, what they believe about the world, and what their approach to law and judging is. So we look forward to continuing this conversation so we can explore those concerns. Thank you so much for joining us this evening, and we will see you again soon.
Bye.